So the role of police is clear to you. Okay, so when the role of police is done, then what happened? Then I was telling you that police investigations always have to be conducted in accordance with the law. कि उनको law को follow करते हुए ही सब कुछ करना पड़ता है, and they have to give respect to the human rights also while arresting the person also. So I was telling you that this Article 22 of the Constitution and criminal law guarantee to every arrested person the following fundamental rights. So there are some rights of the accused person also. I think we were here only. Just confirm me. Rights of the
Yes, ma'am.
accused person. Okay, yes. So
Yes,
what?
ma'am.
Yes, so this is important paragraph, that what are the rights of the accused person also. It is not like that anyone can, the police can come and directly take you away. So there are proper guidelines which have to be followed, which are required at the time of arrest. Okay, first is the right to be informed at the time of arrest of the offense for which the person is being arrested. Okay, so for what thing, or for what charge or what issue you are being arrested, so that time the police has to inform the person. उनको इन्फॉर्म करना पड़ता है. दे कम विद मेमो लेके आते हैं जिसमें पेपर्स होते हैं. दे टेक द साइन आल्सो एंड एवरीथिंग इज रिटन इन दैट कि व्हाई दे आर अरेस्टिंग द पर्सन, and they have to inform the accused person also कि that why they are arresting him or her. Fine. So first right is the right to be informed at the time of arrest. Second is the right to be presented before a magistrate within 24 hours of arrest. So this is also there, that when the person is arrested, so the police cannot keep the accused person or the arrested person for more than 24 hours in the police custody only. So within 24 hours उनको magistrate में जो भी है उसका जो चार्जेस हैं चार्ज शीट बना के कोर्ट में फाइल करके, एंड विद इन 24 आवर्स ऑफ अरेस्ट दे हैव टू प्रेजेंट द अक्यूज्ड पर्सन इन फ्रंट ऑफ द कोर्ट कि आगे जो नेक्स्ट प्रोसेस स्टार्ट करने के लिए. देन थर्ड राइट इज द राइट नॉट टू बी इल ट्रीटेड और टॉर्चर्ड ड्यूरिंग अरेस्ट और इन कस्टडी. यू मस्ट हैव सीन इन द मूवीज कि उठा के ले जाते हैं, पीटते हैं, ये वो इतना टॉर्चर करते हैं एंड ऑल दैट. वी हैव सीन दैट, but that is not the truth. Okay, it is not, you can say, allowed to ill treat or torture any person in the during the arrest or in the custody. So it is the right of the accused person not to be ill treated, कि कोई ill treatment नहीं उसको मिलेगी या फिर torture नहीं किया जाएगा during the arrest or in custody. Okay, these are the rights which all of us must know this. Then fourth is confessions made in police custody cannot be used as evidence against the accused. Now this is very important, very important right is there. Now what happened, you know that everyone is scared of the police, कि सबको डर लगता है पुलिस में. And when the police is taking the person to the jail in the custody, and if they are torturing him, beating him, उसको मार के पुलिस ने प्रेशराइज करके उसको कुछ भी स्टेटमेंट, so obviously when the any person is getting beaten up, so वो डर के मारे तो बोल ही देगा कि हाँ भाई चलो मैंने ही किया है. So what the option is? Okay, so under the fear and under the pressure of the police, the statements which are given by the accused person in the police custody, वो confessions, it cannot be used as evidence against the accused. वो court में as an evidence नहीं use हो सकती हैं. Why? Because you know, I told you the reason. Okay, so this is very important point. Here it is written also. See question, they have framed a question out of this. Why do you think there is a rule that confessions made during police custody cannot be used as evidence against the accused? ठीक है, क्यों नहीं? Because I told you कि that confessions which the accused person is making under the fear and pressure of the police, that are just out of fear. वो सिर्फ डर की वजह से, प्रेशर की वजह से वो स्टेटमेंट दे देते हैं, बट द पुलिस कैन नॉट यूज दोज एज एविडेंस कि हमने तो मार पीट के इसको कन्फेस करवा लिया, बुला लिया है कि इसने किया है. ठीक है, सो दैट्स व्हाई दिस इज इंपॉर्टेंट वन. Confessions made in police custody cannot be used as evidence against the accused. Then a boy under 15 years of age, not a boy, even a girl also. Okay, they mean to say a child of 14, not a child, you can say teenagers. Okay, 15 or 14 or 15 years of age, and women also cannot be called to the police station only for questioning. ठीक है। सो ऐसा नहीं होता है कि वो किसी भी टीनेजर्स को या फिर वुमेन को, दे पुलिस कैन नॉट कॉल देम ओनली फॉर क्वेश्चनिंग, कि सिर्फ पूछताछ के लिए कभी भी उनको बुला नहीं सकते हैं, दे डोंट हैव द राइट। एंड इवन टू अरेस्ट द वुमेन आल्सो देयर हैज टू बी वुमेन पुलिस, ओके, लेडी पुलिस होनी चाहिए, ओनली दे कैन अरेस्ट द वुमेन इफ दे आर गोइंग टू, men cannot arrest the women accused. Fine. So these are some of the rights which are important. You can take all these. And then what is there? The Supreme Court of India has laid down specific requirements and procedures that the police and other agencies have to follow. That I told you. For the arrest, he arrest ke time pe detention. Detention means to keep the person in the custody. That is called detention, and interrogation of any person. So during these three things, there are some specific you can say guidelines which and procedures which are to be followed. These are known as DK Basu guidelines. Okay, this is also important here. DK Basu guidelines. Now, who was DK Basu? He was a social activist from West Bengal. Okay, उस time पे when British rule was there, so that time what he saw that when the police was taking the persons under arrest, कि जब किसी को भी arrest में लेके जाती है तो पुलिस, तो there is lot of confusion. So police is just doing the things on their own, अपने आप में ही वो जज बने फिरते हैं, and what all they are doing. So he felt that this is not right what the police was doing, कि उनको किसी को भी ले जा रही है, and the police who are coming to arrest the person, they are also not in proper uniform, they are not wearing their name tags and all that, and they are taking the person, unko illegally they are getting beaten up and they are getting tortured, and the police was just doing according to their own. So what he felt that time, that there should be some guidelines which need to be followed while arresting the person. So that's why this person, so he wrote a letter to the Supreme Court that time, and then this guidelines were, you can say, laid down by the Supreme Court of India, ki yes, this issue was there at that time. So that's why this name was given DK Basu guidelines. Okay, so these are not, and what are these DK Basu guidelines? And some of these include what? So what are these guidelines? First is the police officials who carry out the arrest or interrogation should wear clear, accurate and visible identification and name tags with their designation. So whosoever, if any police officer is coming for the arrest, to arrest someone, so he should wear प्रॉपर यूनिफॉर्म में होना चाहिए, ठीक है, उसका जो आइडेंटिफिकेशन होने चाहिए कि ही इज एट व्हाट रैंक, कि उसकी पोस्ट क्या है एंड ऑल दैट, सो उसके जो क्लियर विजिबिलिटी होनी चाहिए, आइडेंटिफिकेशन होना चाहिए, एंड नेम टैग्स ही शुड आल्सो वियर, he should wear the name tags with their designations. Designation means at what post that police officer is who is coming for the arrest. Fine. So first is this one. The second is a memo of arrest should be prepared at the time of arrest. एक memorandum बनना चाहिए, मतलब papers होते हैं वो जो साथ में लेके आते हैं at the time of arrest, and should include the time and date of arrest. So at that time, in that memo, it should be written कि time क्या है and date क्या है, what is the time and date of arrest. It should also be attested by at least one witness who could include a family member of the person arrested. अब ऐसे नहीं है कि कहीं किसी को भी कहीं से भी उठा के ले जाए. Okay, so when they are arresting any person, so that time one witness should be present from the family member of the accused person. ठीक है, उसके साइन होते हैं वो मेमो पे. So if the police is arresting any person, and that time the witness should be a family member and he needs to sign on the memo which the police is bringing with them. Fine. The arrest memo should be countersigned by the person arrested also. So उस पे विटनेस के भी साइन होंगे, who could include a family member भी हो सकता है या कोई रिलेटिव हो सकता है, and at the same time it should be countersigned by the person arrested also. ठीक है, जो अरेस्ट हो रहा है उसके भी साइन होंगे, and any witness, it could be a family member or a relative. Fine. So this is the process where the guidelines, DK Basu guidelines they are called. Then the next is the person arrested, detained or being interrogated has a right to inform a relative, friend or well wisher. ठीक है, अब जो पर्सन अरेस्ट हो रहा है, सो ही हैज द राइट, अगर वो अकेला है उस टाइम पे, इफ नोबडी इज देयर विद देम, सो दैट टाइम ही हैज द राइट टू इन्फॉर्म उसको रिलेटिव या किसी को भी इसको अगर इन्फॉर्म करना है, कॉल करना है, सो ही इज अलाउड टू डू दैट. ओके, व्हेन अ फ्रेंड और रिलेटिव लिव्स आउटसाइड द डिस्ट्रिक्ट, फॉर एग्जाम्पल अरेस्टेड पर्सन का फ्रेंड या रिलेटिव वहां पे कोई नहीं है एंड बाहर रहता है कोई आउटसाइड द डिस्ट्रिक्ट, देन द टाइम, place of arrest and venue of custody must be notified by police within 8 to 12 hours after arrest. Now अब जब ले जाते हैं अरेस्ट करके, ओके, सो व्हेन दे आर टेकिंग द पर्सन आफ्टर अरेस्टिंग, दे आर टेकिंग कि उसको कहाँ पे लेके जा रहे हैं, ठीक है, विच इज द प्लेस ऑफ अरेस्ट, कि कहाँ पे उसको रखा गया है. सो एवरीथिंग police, they have to notify to the friend or relative who is living outside the district. ठीक है, so that is the right of the accused person कि उनके भी कुछ rights होते हैं. It is not like that कि हमें पता ही नहीं है कि arrest करके कहाँ पे लेके गए हैं and where they have kept him or her. Okay, so these are some of the guidelines, you can say these are DK Basu guidelines which were proposed by him, and they are now being followed also, just to have transparency and you can say the accurate procedure which is to be followed during the time of arrest and what is need to be required. Okay, ऐसे नहीं होता है कि you must know all this कि what is to be done and how it is to be done, कि क्या क्या rights होते हैं arrested person के भी at that time. It is not like that that he is just taken up and nobody knows that where the police is taking that arrested person. Fine, so these are known as DK Basu guidelines. Okay, so this is just an activity we can do later. This is just related to the Shanti's case. Okay, now then is FIR. So see, these things are just getting repeated. You already know what is FIR. So just read this paragraph quickly. What is FIR? We all know it is first information report and what it includes. Now this paragraph will tell you that what the things are required in while writing the FIR. Fine. So it is with the registration of an FIR. This is the first, you can say, foremost step of any investigation. कोई भी crime जब होता है, so this is the very first step, that it is with the registration of an FIR that the police can begin their investigations into a crime. ठीक है, so सबसे पहला step होता है FIR, and the law states that it is compulsory for an officer in charge of a police station to register an FIR whenever a person gives information about a cognizable offense. Now, what is cognizable offense? कॉग्निजिबल ऑफेंस होते हैं जो सीरियस ऑफेंस होते हैं. सीरियस ऑफेंस मींस लाइक मर्डर हो गया, ओके, कोई बहुत बड़ी थेफ्ट हो गई, so something like that. So murder में if there is an eyewitness, so then there are some offenses where the police need not require the permission of the court. ठीक है, वहां पे वो क्विक एक्शन भी ले सकते हैं बिकॉज एवरीथिंग इज क्लियर. अगर किसी ने देखा है कि यस दिस पर्सन हैज मर्डर्ड दैट, so that is cognizable offense, means very serious offense, and there the police can quickly act without the permission of court also. ओके, ये नहीं है कि पहले वो अरेस्ट ऑर्डर लेके आएगी फिर जाके अरेस्ट करेगी. सो इफ देयर इज एन आई विटनेस, so then also it can be done. Fine. So first of all FIR, and then it is compulsory for an officer in charge of a police station to register an FIR whenever a person gives information about a cognizable offense. Okay. Yes, okay, so this information can be given to the police either orally or in writing. ठीक है, so पुलिस की ड्यूटी है FIR लिखना. अगर कोई पर्सन आ रहा है और उसने बोला कि हाँ मैंने देखा है this crime, this thing has happened here, so police cannot deny him, and police, they have to write an FIR whenever a person gives information about a cognizable offense, very serious offense. So this information can be given to the police either orally or in writing. ठीक है, the FIR usually, now this is important, underline these lines, what is there in FIR. The FIR usually mentions the date hoti hai, time, and the place of the offense, details the basic facts of the offense. What are the basic facts of the offense means what has happened, कि किस तरह का crime हुआ है, including a description of the events and how it has happened. Okay, so what, how, where, when, all these questions, all these WH questions are written in the FIR. If known, the identity of the accused persons and witness is also mentioned. कई बार पूछते हैं कि कोई FIR लिखने आया तो बोलते हैं कि वो दिखने में कैसा था, okay, what was the height and how, what kind of hairstyle was there. So if known, द आइडेंटिटी ऑफ द एक्यूज्ड पर्संस और कोई विटनेस है उसका भी मेंशन होता है उसमें. द एफआईआर आल्सो स्टेट्स द नेम एंड एड्रेस ऑफ द कंप्लेनेंट. नाउ हु हैज कम टू फाइल एन एफआईआर, उसका भी नाम और एड्रेस. नाउ दैट इज अ कंप्लेनेंट, वो कंप्लेनेंट बन के आया है बिकॉज ही इज कमिंग टू फाइल अ कंप्लेंट. So उसका भी नाम और एड्रेस will be included in the FIR. There is a prescribed form in which the police registers an FIR. ना ऐसे नहीं है कि कोई भी पेज ले लिया और उस पर लिख दिया सारा कुछ. No. So there are proper forms like you get admission from the school. So वैसे ही पुलिस में FIR का फॉर्म होता है proper जिसमें all the particulars and columns are already written. So you just have to fill, police fills that, and after that, very important, it is signed by the complainant. Okay, first it is filled, every the whole information is filled in the FIR, and then it is signed by the complainant. And lastly, very important, the complainant also has a legal right to get a free copy of the FIR from the police. ठीक है. सो जो भी FIR लिखवाई है जाके उसकी आपको एक कॉपी भी, that you have the legal right to ask for the copy of the FIR. Fine. So these all things are related to FIR, which is important. So you know what all things are mentioned in the FIR, and some more that whose all signs are required. And the last one is very important, that it is the legal right of the person of the complainant to get a free copy of the FIR from the police. Fine. So now you are clear with the role of the police, and you know about the rights of the accused persons, you know about DK Basu guidelines, and you know in details about FIR also. Fine. So we are left with two things now. What is the role of public prosecutor and what is the role of the judge? So we have already studied the case of Shanti. Okay, you already know. So again, these are just the repetitions, the generalized functions of the public prosecutor. So a criminal offense, I have already told you these things while I was telling you the Shanti case. So now these are just written and the revision of all the previously done things only. So what is the role of public prosecutor? I already told you. Public prosecutor is acting on the behalf of the state, because if any crime is happening in the state, so that is considered as पब्लिक रॉन्ग. ठीक है. जो कोई भी क्राइम होता है स्टेट में, सो वो एक स्टेट के अगेंस्ट होता है. ठीक है. बिकॉज इट इज द ड्यूटी ऑफ द स्टेट कि स्टेट में कोई क्राइम ना हो. सो एवरीथिंग देयर शुड बी स्मूथ फंक्शनिंग. ठीक है. बट इफ एनीथिंग रॉन्ग इज हैपनिंग, सो इट इज रिटन द वेरी फर्स्ट लाइन, a criminal offense, कि कोई भी अगर क्रिमिनल ऑफेंस होता है, is regarded as a public wrong. उसको एक public wrong बोलते हैं. Why public? Because public is the people. So it is against the state. State is for the people only. So it is against the state, against the government, against the people. What is meant by this is, इसका मतलब क्या है public wrong का? What is meant by this is that it is considered to have been committed not only against the affected victim. ऐसे नहीं है कि जो जिसके अगेंस्ट किया गया है, कोई एक पर्सन के खिलाफ वो क्राइम नहीं हुआ है, बट इट इज अगेंस्ट द सोसाइटी एज अ होल. Okay, so if any crime is happening, any criminal offense is happening, that is not only against the person, उसमें सिर्फ एक person ही involved नहीं है, because that is against the society, because उसका जो effect है वो पूरी society में पड़ता है. Now if anything wrong is happening in our society, so obviously उसका effect हम पूरे लोगों पे पड़ता है. हम पूरे जो जितने भी लोग society में रहते हैं, we become alert that this kind of happening has taken place, so we have to be alert of regarding that. So that's why these kind of things, they are considered as public wrong, because these are not only against one affected victim, these are against the society as a whole. So that's why it is the duty of the government to take care of all these things, that these things should not happen. And if anything has happened like this, so then also it is the duty of the state to prove that the person who has done that is accused and he is guilty of that, and proper punishment or sentence, he should be sentenced for whatever he has done. And for that, the state government is having this public prosecutor. So public prosecutor ये state के behalf पे काम करते हैं. ठीक है. And they are presenting the case in the court if anything wrong is there. So do you remember the case of the dowry death of Sudha? If you remember, हमने वो पढ़ा था जुडिशरी में. that we read about in the previous chapter. The case against the accused Lakshman and his family was presented by the state. ठीक है. So जो केस था लक्ष्मण और इस फैमिली का, सुधा को उन्होंने जला दिया था, so that was also presented by the state. Why? Because the case was called state versus Lakshman Kumar and others, because जो criminal offense हुआ था वो किसने किया था, लक्ष्मण कुमार और उसके family members ने. So that's why we can also say, हम ऐसे cases को we can also say like state versus Lakshman Kumar and others, because they did the crime which was against the society. Okay, so that's why it was known as, usko bolte hain state versus Lakshman Kumar and others, because one side the state is there, the people are there, society is there. Similarly, the above case जो हमने शांति का केस पढ़ा है उसको भी हम बोल सकते हैं. Similarly, the above case can be called state versus Shanti Hembram. Okay, now why Shanti? Because we know that कि शांति की कोई गलती नहीं थी, but according to the law जो चोरी हुई है that is a crime, ठीक है, which is publicly wrong. And for that accused कौन था, शांति थी. But later on means she was released, she was acquitted because she did not do anything wrong. But we can call that case also because against में कौन था, state थी. So state से कौन represent कर रहा था, public prosecutor था, and public prosecutor versus Shanti Hembram. So one side defense was there, Shanti Hembram, and the other side was the public prosecutor who was presenting the case against the for the state, and he was trying to prove Shanti guilty in that case. Okay, so जो अगर कुछ भी wrong होता है, so वो public prosecutor present करता है केस में, and not Mrs. Shinde versus Shanti Hembram. So उस केस को भी हम बोलेंगे state versus Shanti Hembram, and not Mrs. Shinde versus Shanti Hembram. I hope it is clear. If it is any doubt is there, you can ask. In court, it is the public. Yes, yes. Yes.
मैम मैंने पूछना है कि
पूछो.
मैंने देखा था कि उसमें होता ये है कि मतलब कि एक लेडी का मर्डर हो जाता है उसके रिलेटिव के सामने.
ओके.
एंड वो मतलब कि अपने फ्रेंड लॉयर को ये बताती है, एंड पब्लिक प्रोसिक्यूटर नहीं होती, वो प्राइवेट लॉयर होती है, एंड वो पब्लिक प्रोसिक्यूटर में केस लड़ती है. ऐसा हो सकता है?
ऐसा थोड़ी होता है. पब्लिक प्रोसिक्यूटर दे आर अपॉइंटेड बाय द गवर्नमेंट इन कोलैबोरेशन विद द हाई कोर्ट. प्राइवेट लॉयर थोड़ी पब्लिक प्रोसिक्यूटर बन सकता है. प्राइवेट लॉयर कैन ओनली हेल्प पब्लिक प्रोसिक्यूटर. मैंने ये पहले भी बताया था कि अगर आप अपना प्राइवेट लॉयर करना चाहते हो, यू कैन हायर, बट कोर्ट में प्रेजेंट जो केस करेगा वो पब्लिक प्रोसिक्यूटर ही करेगा. ठीक है. द प्राइवेट लॉयर कैन ओनली हेल्प द पब्लिक प्रोसिक्यूटर. ऐसा नहीं होता है, प्राइवेट लॉयर नहीं प्रेजेंट करता है. ओके. So, okay, in court, you see it is written here, the very first line of the second paragraph. In court, it is the public prosecutor who represents the interests of the state. So the role of the prosecutor begins once the police has conducted the investigation and filed the charge sheet in the court. ठीक है. सो प्रोसिक्यूटर का रोल बाद में शुरू होता है. पहले पुलिस अपनी इन्वेस्टिगेशन करती है और जब चार्जशीट फाइल कर देती है, सो देन द रोल ऑफ द प्रोसिक्यूटर बिगिंस. उसके बाद प्रोसिक्यूटर देखता है सारा केस की क्या है क्या नहीं है, एंड ही और शी हैज नो रोल टू प्ले इन द इन्वेस्टिगेशन. इन्वेस्टिगेशन में वो रोल नहीं है, उसका सिर्फ काम है प्रेजेंट करना केस को. Okay, so investigation is done by the police and the charge sheet is filed by the police, and then the role of the prosecutor begins, and then he is presenting the case based on the evidences which the police has given. Okay, the prosecutor must conduct the prosecution on behalf. So the prosecutor must conduct the prosecution on behalf of the state. I told you, as an officer of the court, it is his or her duty to act impartially. Impartially means not in favor of someone. ये ऐसे नहीं है कि कोई इसमें इमोशनल इंक्लिनेशन नहीं होती है.
वीडियो ऑन करनी पड़नी.
ठीक है. सो जो पब्लिक प्रोसिक्यूटर होता है उसकी ड्यूटी होती है टू एक्ट इम्पार्शली. ऐसा नहीं है कि जो उसको मीन्स मिले है कि आपको ये प्रूव करना है, बट आफ्टर हियरिंग ऑल द टेस्टिमोनीज जो भी हैं उसको एक इम्पार्शली एक्ट करना होता है कि नॉट टेकिंग द साइड ऑफ एनीवन. ही विल ओनली टेक द साइड ऑफ द स्टेट, ठीक है, एंड अगेंस्ट द क्राइम which has happened, and present the full and material facts, witnesses, and evidence before the court to enable the court to decide the case. ठीक है. सो जो भी केस है उसके लिए क्या चाहिए, जो फैक्ट्स, विटनेसेस, एविडेंस, सो ही इज प्रेजेंटिंग बिफोर द कोर्ट सो दैट द कोर्ट इज एबल टू डिसाइड द केस. सो दिस इज द रोल ऑफ द पब्लिक प्रोसिक्यूटर. फाइन, क्लियर. Next is what is the role of the judge. Very simple role is there, you know. The judge is like an umpire in a game. So the last, you know that what is the role of umpire. Umpire is the last decision making person of the game. ठीक है. जब लोग लड़ते हैं कोई solution नहीं होता है, so then it is up to the umpire. So same way the judge is to take the decision. The judge is like an umpire in a game and conducts the trial impartially and in an open court. Open court means uh, the other persons also can come and have listen to the hearings of the court. So the judge hears all the witnesses, सबको वो सुनता है, and any other evidence presented by the prosecution and the defense. So जितने भी evidence prosecution पेश present करती है या defense present करती है उन सबको he hears all the witnesses and reads everything. The judge decides whether the accused person is guilty or innocent on the basis of the evidence presented and in accordance with the law. Fine. So whenever all the things are presented, and then the judge has to decide whether the person is guilty or innocent. If the accused is convicted, convicted means if he is proved guilty, then the judge pronounces the sentence. Okay, sentence means what? Sentence here doesn't mean that English wala sentence nahi hai. Here pronounces the sentence means punishment. Means what all the uh, jail kitni hogi ya koi fine hoga. What all the things are there. That is called sentence in court language, you can say. Okay, so the judge pronounces the sentence. He may send the person to jail or impose a fine or both भी हो सकता है, fine भी, jail भी, depending on what the law prescribes. क्योंकि हर law के हर क्राइम के लिए लॉ बने हुए हैं कि अगर इसने ये क्राइम किया है तो क्या लगेगी, which कौन सी धारा लगेगी. So all the things are already written in the constitution. So uh, whenever this person is proved guilty, so the judge pronounces the sentence according to the law. Fine. This was very simple one. Then last is what is a fair trial. Fair trial is, I already told you in the beginning also, जब शांति का trial हुआ था, she was pleading that she says I plead not guilty and I claim trial. उसने बोला था. Okay, so why? Because she wanted to present her side. She wanted to defend herself. Otherwise क्या होता अगर उसको बोलने ना दिया जाता, अगर उसको कोर्ट में चार्जशीट ना दी जाती, उसको लॉयर ना दिया जाता, because just because she was poor, कि वो पुअर थी, कुछ अपना लॉयर नहीं हायर कर सकती थी या उसके पास पैसे नहीं थे, सो देन इट वुड नॉट हैव बीन अ फेयर ट्रायल, यू कैन से. ओके, अगर बिना ये सब चीजों के उसको एक सेंटेंस दे देते कोर्ट की नहीं तुमने चोरी की है, ये जाओ जेल में जाके सड़ो, सो दिस देन दिस वुड नॉट हैव बीन अ फेयर ट्रायल. ठीक है. फेयर ट्रायल में कुछ कॉन्स्टिट्यूशन में जो लॉ बनाए हैं कि इफ द पर्सन इज नॉट एबल टू हायर द लॉयर बिकॉज ऑफ पॉवर्टी, सो देन ऑल्सो इट इज द ड्यूटी ऑफ द गवर्नमेंट टू प्रोवाइड द लॉयर and for having to hear the person also in the court. So that is called fair trials. Okay, so let us for imagine, for a moment imagine, एक moment के लिए imagine करो what might have happened if the judge decided to try Shanti's case very differently. अब एक situation imagine करो, क्या situation है? What if the court did not give a copy of the charge sheet and statements of witnesses to Shanti? क्या होता कि अगर कोर्ट वो चार्जशीट की कॉपी और विटनेसेस ने क्या बोला है, मिस्टर मिसेस शिंदे ने क्या बोला है उसके खिलाफ, अगर उसको ना पहुंचाते. व्हाट इफ ही हेल्ड द ट्रायल, what if he held the trial in a secret location where neither Shanti nor Sushil were present? कि अगर कोई ऐसी जगह पे ट्रायल होता है जहां पे ना शांति है ना सुशील है, उनके बिना ही कोर्ट अपनी जजमेंट सुना देते, क्या होता? What if he did not give Shanti's lawyer, कि अगर वो शांति को लॉयर ना देते, advocate Roy, enough time to question the witnesses of the prosecution such as Mrs. Shinde, and instead had already decided that Shanti was guilty? कि क्या होता कि अगर उसको लॉयर ना देते, और लॉयर ने जो किया कि प्रोसिक्यूशन को पूछा, मिसेस शिंदे को पूछा, एंड क्या होता कि अगर जज वैसे ही डिसाइड कर लेता दैट शांति वाज गिल्टी? इफ दिस हैड हैपेंड, कि अगर ऐसा कुछ हुआ होता, देन इट वुड बी अ केस ऑफ एन अनफेयर ट्रायल। ठीक है, कि अगर ये चीजें होती, सो देन इट वुड